Good afternoon, everybody. Last time we got together, we did a little trial time, and we had a whole lot to do and a little time to do it. Same thing today. We're going to go over a lot of material, and this will probably we will probably move on next month and hit additional material because there's just so much to know about preparing for trials and presumptions. There is a rebuttable presumption. We're going to toss independent contractors out there for a second. Injured workers are performing services for which a contractor's license is needed. It's legally required. Or if they're working for somebody else who is required under law to have such a license, they will be deemed employees, not independent contractors, and therefore there are a problem if they get injured unless there's sufficient evidence to prove independent contractor status. And there's a myriad of pieces of factual pieces that need to be pieced together to demonstrate independent contractor status as a defense. Or, and this is the strange one, if they work less than 52 hours or earn less than $100 during the 90 days prior to their date of injury, then we're going to have ourselves a defense. What about the 90-day rule? That tends to be confusing. I think we all know that an injury is presumed compensable if it's not denied within 90 days after the receipt of the claim form. Now that is rebuttable, but you only can use to rebut information that would not have been otherwise obtainable during the 91st days, and that's a rather tough putt. I do want to point out that the Labor Code says after the date of the claim form is filed. There's a little confusion. In fact, there's a lot of confusion as to what the real rule is. Some people think that if there's some sort of notice other than a claim form being filed, that this will start the 90 days, and that's not necessarily the case. And there was a Supreme Court case directly on point. So if you're facing this issue, give me a call, and I can give you more of the particulars. If the night, as I just suggested, if we miss the 90 days, the burden shifts, and any and all evidence will be excluded other than that, which the employer could not have otherwise obtained during the 90 days via, and the magic phrase here is reasonable diligence. Public safety officers, we're going to spend about 3 minutes on public safety officers because many of you don't deal with that, but they are statutorily favored employees and have statutorily covered conditions. In short, the Labor Code makes special exceptions and exemptions for these folks. And the primary one is that conditions manifested when an officer is serving as a listed agency receives a prima facie evidence of the injury AOE COE. This presumption is incredibly difficult to overcome. With some conditions developing or manifesting in the service of the employer, quote, shall in no case be attributed to any disease existing prior to that development or manifestation. I'm sure you've heard of the non-attribution clause, and as you've worked in the industry, that's exactly what it is. Which leaves open the question, how does an employer defend against this? Well, it's simple. Got to prove a contemporaneous, non-work-related event that was the sole cause of the injury. We cannot use evidence that the injury was attributed to a pre-existing disease. Tough putt? Yeah, it's really tough. Now, if the non-attribution clause doesn't apply to the particular public employee, the employer can rely on information or evidence that the injury was attributed to a pre-existing disease, not AOE COE. But if that attribution clause is in there or the non-attribution clause is in there, there's a very, very tough putt. Let's start new topic. Applicant has been awarded TD, or you've stipulated the TD, and the doctors say MMI. You can't and don't want to immediately cut off TD. You've got to file for a petition to terminate. Labor Code Section 4651.51 says where a petition is filed, there shall be a rebuttable presumption that such TD continues for at least 1 week of the filing. So as soon as the doctor has cut off file your petition to terminate. If you're down at the board and applicant's counsel wants to concede to temporary disability status, and you have a good reason to do so, and have to sign a stipulation, or have your attorney sign a stipulation to TD, continuing TD, include in that stipulation a waiver of Labor Code Section 4651.1. In over a quarter century of doing this, I've always included that provision in my stipulations, and nobody has ever argued the point. So that way you waive any need to file the petition to terminate, or probably more importantly, remember to file the petition to terminate. What if you're really, really naughty, or the other side is really, really naughty? What do I mean by that? Where somebody hides a medical report, and they willfully do so. It shall be presumed that anything in that report, any point in that report, would have been to the negative. In other words, let's say that the report said it was not AOE-COE, and yet he hid the report, it would be found to be AOE-COE. That would be with regard to every issue in that report. Now, you have to prove that it was willful, not just negligent or stupid, but if you can prove willful against the other party, you're going to have a dead bang winner virtually every time. The unemployment compensation disability lien, not much to say there. These are rebuttably presumed correct, correctly stated, and it's presumably presumed that the amounts paid, amounts as stated to the applicant as stated by EDD as stated. The state does not need to prove the amounts paid to the applicant, and if you think about it, that makes sense. Why would they lie? They really don't have a vested interest in lying. The only problem was where they made a mistake. They made a mistake, and as I suggested, this is a rebuttable presumption. So if you've got information suggesting that there was a calculation error, you're certainly in a position to rebut that presumption. Okay, here's a fun one. Non-industrial deaths for refusal to authorize an autopsy. We got a death case, and they're not in the custody of the coroner, easy for me to say. The WCAB can authorize an autopsy. And if they're buried in the ground, the WCAB can order that they be pulled out of the ground. Kind of yucky. However, if one of the dependents or all the dependents have custody of the body, who has custody of the body, refuse to allow the autopsy, the WCAB cannot order it. It doesn't have the power to do so. That having been said, we're in the driver's seat if the applicant's dependents refuse to have the body undergo an autopsy. Why? Quote, in such case, upon a hearing of any application for compensation, it is a disputable presumption that the injury or death was not due to causes entitling the claimant to benefits under the division. In short, we're probably going to win. Witness testimony. We've got recipient witness testimony and expert witness testimony. Not everybody gets to talk. Lay witness, generally, yes. Physicians, VR experts, generally, no. But regardless, some issues do require a quote-unquote expert opinion, and we're going to talk about that. Without an expert opinion, not in testimony usually, but through a report, the lay testimony, the recipient witness testimony won't do the trick. Of course, it's up to the judge to determine whether the witness seems credible. So you want to make sure. Oh, here's a point. If you're going to be going to trial and you list some witnesses, be sure to subpoena them, even if they're your own witnesses. And people will say, well, wait a minute, it's my employer, it's my manager. They're going to want to show up. Absolutely, I completely understand that. But you want to subpoena them for this reason. If on the appointed day for the trial, your witness gets in a car accident or forgets the date of the trial, or for whatever good faith reason doesn't show up, if you've got the subpoena, you can show the judge that, and the judge will provide extra time to get that witness before him or her. If you don't have a subpoena, the judge is going to simply ask, did you subpoena that witness? If the answer is no, you're probably out of luck. So what I normally do is call the witness before I subpoena them, because people are scared of subpoenas. They typically have subpoenas. They don't receive them all the time. Call them up, tell them, I know you're my buddy, you're my pal, or you're our witness, but I'm going to subpoena you anyway. Here's the reason I'm going to subpoena you. And I also provide them a little form, typed out form, saying that they know that they've been subpoenaed, that they're going to show up for to give testimony, have them sign and date that. So I'll have that also to show it to the judge. All right. The WCAB favors the production of medical evidence in the forms of written statements. Direct examination of medical witnesses won't be allowed except for a showing of good cause. Have you wondered why we virtually never, and in many people's experiences, never see doctors testifying down at the board? It's because they're not allowed to unless there's a showing of good cause. In 25 years of doing this, I've seen exactly one doctor, or I've had exactly one doctor testify. More about that later. Why doesn't the judge want to assess credibility and instead just look at reports? Well, it's real simple. Let me read this. Utilization of written medical reports allows for the expeditious handling of cases by eliminating time-consuming and often unnecessary oral medical testimony. It also gives the doctor an opportunity to spell out his or her arguments and thoughts and logic in a well-reasoned and orderly presentation. So it saves time, it saves money, and due process is okay. You might say, well, wait a minute, we can't cross-examine the applicant or the doctor. Certainly you can at deposition. And lastly, there's always the concern about the judge being able to assess the doctor's credibility. But, you know, it's a very small industry. We swim around in a very small pool called workers' compensation. The judge is going to know the expert's reputation and whether or not they can be relied upon. Can doctors or VR experts ever testify? Yeah, absolutely, but it's virtually never going to happen because there must be a very, very good reason. One of the reasons might be that the doctor is a percipient witness. That is, that they're not testifying an expert witness, but because they saw something or felt something or heard something. So the testimony is not it's not dealing with a medical issue per se, but is rather something that anybody could testify to without an MD at the end of their name. The one time I dealt with a case in which a doctor testified, it was in favor of the doctor's lien, or he was arguing in favor of his lien. I was defending against that. Very surprised to see the doctor show up. It doesn't happen too terribly often. The injured worker need not testify. In fact, it can win without testifying, although that's not usually how it works. If the injured worker does testify, invariably they're going to be testifying as a lay witness or a percipient witness, who's somebody who simply is defined in the negative. A percipient or lay witness is somebody who is not testifying as an expert. So why have the injured worker testify? Obviously to explain what happened, how it happened, what benefits are alleged, et cetera, et cetera. In short, because they're a lay witness, they can testify to what they hear, they tasted, they smelled, they felt, they saw, that kind of thing, but not to opinion. Important. Obviously, our witnesses need to seem credible and be sympathetic. So why not have the applicant testify? Oftentimes, applicants' attorneys will refuse to proceed because they think they're going to argue the testimony is duplicative, or just explain to the judge, hey, it was duplicative, I'm okay. But in all likelihood, the applicant is unsympathetic. Does this outfit make me look fat? Sometimes we should not be providing opinions. As I suggested earlier, if you're a recipient or lay witness, your opinion is irrelevant. You can only testify to what you tasted, touched, felt, smelled, etc., what you experienced through your senses. if the question asks for an opinion, that's the time that we use an expert witness. And here's the evidence code. I know we usually exclusively rely on the labor code in workers' compensation, but here's what the evidence code says. 720, a person is qualified to testify as an expert if he has special knowledge, skill, experience, training, or education sufficient to qualify him as an expert on the subject to which his testimony relates. Against the objection of a party, such special knowledge, skill, experience, training, or education must be shown before the witness may testify as an expert. Obviously, from given this information, we're not including most applicants as experts. Who's the typical witness on the defense side? Obviously, co-employees, some of whom are called by the injured worker to support their claims, called by the employer to obviously undercut the applicant's testimony. Because again, they are not expert witnesses, they are percipient witnesses. They can only they, like everybody, can only testify to what is relevant. Causation of the injury. Sometimes we can use lay testimony for medical issues. Sometimes we require medical testimony. If the injured worker was allegedly run over the car and somebody saw it, there'd probably be sufficient lay testimony without an expert opinion that to prove causation. You would still, of course, need need medical opinion to to establish extent of the benefits, the extent of the injury. But the fact that they got run over, that lay witness can probably help us sufficiently on that. What about when the causation isn't something simple like being run over by a car or falling down some stairs or having a safe fall on our head? What if it's something, causation is something that requires or is a matter of scientific medical knowledge, such as exposure? Well, you're going to need expert evidence for that, obviously. Lay testimony is not going to be do the job. Similarly, if the lay witness testifies to stressors at work, the expert's going to have to provide a diagnosis, causation, and compensability. A lay witness, an applicant's not in a position to measure the impact of stressors on causation, compensability, and diagnoses. Is the witness credible? Is the witness persuasive? That can be for the judge and the WCAB to decide. The judge is going to decide whether everything is supported by substantial evidence, and when they do so, the WCAB is going to give great weight, quote unquote, whatever that means, to the judge's opinion. The reason being, well, real simple. The judge can hear, see, and hopefully not, but sometimes smell the applicant or the witness, and the WCAB is not in a position to do so. It only has the transcripts. So given that the judge is in a better position to review or see and assess the posture and intonation, etc., of the witness, the WCAB is going to give the WCJ wide berth. Contrary, substantial evidence. On recon, what will the WCAB do? They will make their own credibility determinations and can reject the WCJ's decision and enter its own determinations as to whether there is substantial evidence. All right, what about the WCJ's credibility rulings on deposition transcripts without trial testimony? The WCAB is much more comfortable reweighing credibility issues because it's just a transcript. The judge, him or herself, didn't have an opportunity to see the witness, so the WCAB in San Francisco is not at a disadvantage as compared to the judge. All right, lying. Sometimes there's lying, believe it or not. In workers' comp, some people lie. You may not have gotten the memo. Let's see here. If there's some lying, it's not necessarily going to decide how the case is decided. The WCAB and the WCJ need not wholly accept or reject an applicant's testimony. They can believe some of it. They can reject some of it as disingenuous. They can accept testimony that is uncontradicted, unimpeached, and will reject anything that is mere speculation, i.e. a guess or mere conjecture, a surmise. Self-serving. Well, that testimony was self-serving. Objection. Well, of course testimony for one side is going to be self-serving. That doesn't mean it's inadmissible. In fact, that's what's expected. Just because it's even when it's self-serving, that doesn't preclude the judge from drawing inferences from the available evidence, that is connecting the dots. So does the applicant win if there are no other witnesses? Absolutely not. The judge can disbelieve testimony from an applicant even if it's not contradicted, so long as there's a rational basis for disagreeing or disbelieving and the judge is not acting arbitrarily. Cross-examination is often very helpful, but believe it or not, I once had a case in which there was just one witness, the applicant, and I didn't even have to cross-examine the applicant. Applicant's counsel put his client on the stand, examined him, and after the examination, the judge took a look at me and said, does the defense still have $500 to settle this case? The message being, the applicant may not have even proven his case through his own testimony and needn't be cross-examined. So this can happen. Don't expect that to happen too terribly often. Time to lie, does it matter? If there's testimony inconsistencies, false histories, etc., taken together, this can mean, and I want to emphasize the word can or may or might be sufficient to find that the applicant has met his or her burden. But it's not true that all liars automatically lose everything. Here's a pretend cross-X from transcript. Question. When you were hired, you claimed you were John Smith. Correct. And you provided a social security number that was issued to John Smith. Correct. But now you claim you are Bob Brown. Correct. So does the applicant lose? You would think they should lose, but not necessarily. The judge can still decide that this person really is Bob Brown, and that the testimony that they provided regarding their injury is legitimate. I suspect if it's a CT, there's going to be a CT or a psychological problem. It's going to be less likely to be found AOE, COE, than a physical injury where the judge, I think, is going to be more sympathetic when he finds that Bob Brown was run over by a train. What if the judge thinks the applicant lied on the stand, as opposed to in a deposition or to a doctor? You would think the applicant would lie then, but not necessarily. Here's a case that may not, with a fact pattern that may sound familiar. The applicant gave different histories to different doctors. One doctor didn't even get a history, and it was noted that the applicant hadn't sought treatment for 2 weeks post the alleged injury. The judge and the WCAB said, okay, this sounds like a bunch of baloney. The case was obviously fabricated and lied about, and therefore no AOE, COE. It's a defense verdict. The DCA said, no, you judge, you ignored the testimony of co-employees who said, we actually saw the injury. You ignored the medical evidence that was consistent with the alleged injury. And you ignored the medical evidence that made medical, that was appropriate given the claimed body parts. So it was remanded down to the WCJ for further development. Reasonable medical probability. What is that? I kind of think of those as magical words. And it's best to have actually the doctor use those magical words in their deposition and in their medical report, so as to emphasize their degree of comfort with their determination. What helps with reasonable medical probability? Well, you're not going to have reasonable medical probability if the doctor doesn't use a correct legal theory. You're not going to have a reasonable medical probability if the doctor's opinion is based on surmise, speculation, conjecture, or guess. You're not going to have reasonable medical probability if the report is not based on an adequate medical history or examination. Those are usually the three-part tests that are looked at to determine whether a report is true to a reasonable medical probability. As I suggested earlier, the WCAB loves medical reports and records, and there is a long, long list of the types of records that are admissible. I'm not going to go through all of them. I'm just going to let you know that the lists are on slides on 112. All right, trial time. There's medical evidence. I'll just read a little bit to you. Where an issue is exclusively a matter of scientific medical knowledge, expert evidence is essential. Lay testimony or opinion in support of such findings does not measure up to the standard of substantial evidence. We've already addressed this a little bit, looking at expert witnesses versus lay or percipient witnesses. Although lay testimony in some cases may support a finding that the injury arose out of and in the course of employment, in most cases, expert medical opinion is required to establish industrial causation. That's why we go to medical doctors in virtually every case. If medical evidence is required, they must establish causation by a reasonable medical probability. There we go. It's not enough for the physician to simply repeat the applicant's allegations of the injury. And you know what? We often see that in a lot of reports if you read them carefully. It's just a resuscitation of what the applicant said. That's not an analysis, and the doctor must provide an analysis. The doctor must, go back to this quote, must offer his or her opinion as to the cause of the injury, not the applicant's bare bones story. So, as we suggested earlier, the applicant's own testimony or the testimony of co-employees or whomever the applicant brings in to testify can occasionally support the AOE-COE finding, but for the most part, you need experts for causation testifying to a reasonable medical probability. We definitely need the doctor's recitation or own opinion, not just the applicant's war story. Whenever the subject under consideration is one within the knowledge of experts only and not within the common knowledge of laymen, the expert evidence is conclusive upon the issue and question of issue. In short, we're not going to undercut the expert opinion with a lay opinion about the same medical issue. Now, we've determined that in some cases we need lay testimony, in some cases we need expert testimony, in some cases it's great to have both, but you absolutely, positively must have expert opinion for causation of CTs, occupational disease, psyche problems, treatment, MMI, TD, PD, and apportionment. You're just not going to move the stone any distance at all having purely lay testimony or applicant testimony on these issues. So what's a medical report? You know, we see medical reports every day, but do you ever sit back and ask, what is a medical report? Is it like pornography? One of the U.S. Supreme Court Justice Potter was talking about pornography in a case many years ago. He said, I shall not today attempt to further define the kinds of material I understand to be embraced within that shortened description of hardcore pornography. And perhaps I could never succeed intelligibly to do so, but I know it when I see it. Well, I think we all know a medical report when we see it, but how do we define it? Well, the broad definition is, quote, any written communication from a physician which in any way refers to the case in which he or she has been asked to report. And as such, they have to be filed and served pursuant to the board rules. But be careful what you ask for. I just want to check this too. Be careful what you ask for. I have, on occasion, in major cases, lifetime pension and perm total cases, asked for expert opinion to assist in preparation for a deposition of a doctor or deposition of applicant, determine what additional relevant medical records we should be obtaining, that kind of thing. And I will seek the assistance of a doctor who's not part of the workers' compensation system to get their input. And I do not ask for a report. I don't want a quote-unquote written communication. I want to go over this information over the telephone or over lunch or over dinner so that there is no written communication that I must file and serve. So just take that into consideration. One, it may be a good idea with your massively expensive, high exposure cases to use a third party to get you up to speed on the medical issues. And two, you probably don't want a written report. Verbal reports rock, as the PowerPoint says. So Section 10606 provides the litany of things that must be included in the medical report, and it goes, and it goes, and it goes, and it goes, and it goes. But we can't have it all. Despite the fact that everything seems to be a medical report and that everything must be filed and served, some medical evidence is not discoverable. Heck, some medical evidence we don't want to discover. First off, it has to be relevant at the very least. So if you've got a broken leg, you're probably not entitled to medical records relating to the right arm. You certainly aren't entitled for psych records. In fact, you're really going to be having to deal with a psych claim in virtually every situation if you're going to get psych records. Also, you have to consider HIV records. If you've never gotten HIV records and are in a position where you're going to need them, be very, very careful. There are certain specific rules dealing with HIV records. You're going to want to work with somebody who's gone down this path. You may want to talk to the PJ because even the judges are a little weak in this area. Many of them have not dealt with HIV records, but the PJs do oversee that. So this hasn't been as big an issue as it was 20 years ago, but nevertheless, there's an excellent chance you'll run across this at some point in your career, and move very carefully. If you are facing this situation, please feel free to give me a call or text me or email me, and I'll be happy to help you in any way I can. So not all medical evidence is equal. Some cannot be used. You want to determine entitlement to TD and PD, do not bother with acupuncturists or MCCCSs. Per the labor code, they are not allowed to make the TD and PD determination. Want an admissible test? Make sure it follows all of the necessary rules, similar to the rules that apply to regular reports. And don't forget, treating reports are admissible for disputed medical issues, but you need to follow the labor code requirements for necessarily for the dance, etc., or the panel, etc. Boy, that showed me old school. Is evidence susceptible to an inference that is opposite to what the judge found? So the evidence could go either way, but the judge found it. The evidence could go to A or B, but the judge found it to A. Is that a problem? No, it's not. As long as the judge's findings are supported by inferences that are quote unquote fairly drawn from the evidence, the judge's finding is going to hold. Substantial medical evidence. Well, we had a problem determining what reasonable medical evidence is. What's substantial medical evidence? Well, let's read from Bolton. Evidence which, if true, has a probative force on the issues. It's more than a mere scintilla, I love that word, and means such relevant evidence as a reasonable mind might accept as adequate to support the conclusion. It must be reasonable in nature, credible, and of solid value. I'm not sure I've helped you one bit in terms of figuring out what substantial evidence means, but that's the explanation we have. Enjoy. It continues on. Factual findings of the WCAB are not supported by substantial evidence in light of the entire record, where they are in conflict with all the evidence, or they are based on inferences which cannot be fairly drawn from the evidence. Evidence which lacks probative force is purely fanciful conclusion or creation of non-existent evidence. To qualify as substantial, the medical opinion must be predicated on a reasonable medical probability. There's our friend. And it's a no-go if it's known to be erroneous, based on facts that are no longer relevant, based on an incomplete medical history, more about that later, based on an inadequate medical examination, query whether a examination that's done over the phone or via teleconference is adequate. More about that later. Based on an incorrect legal theory, or on surmise, speculation, conjecture, or if the doctor fails to provide reasoning behind their opinion. Couple of these things. First off, based on an incorrect legal theory. We see this all the time in apportionment. If anybody remembers the Escobedo decision, it was the first en banc decision after the passage of SB 899. It came down on April 19th, 2005, 1 year to the day that the SB 899 had passed. And she said it was an en banc decision on apportionment, so it's a very important case. And in that case, Ms. Escobedo was found to pre-injury have had no symptoms in her knees, no subjective complaints, no previously objective problems, no treatment, no self-restrictions, no restrictions placed on her by the doctor, etc. Nevertheless, the doctor, Dr. Ovadia, opined that she had 50% apportionment to prior existing factors. So she was completely without symptoms. Nevertheless, he apportioned prior to the injury. And nevertheless, he apportioned 50% away to previously existing conditions. And that was held up by the WCAB. Now, interestingly, I see a lot of times in reports under apportionment where the doctors say, provide the exact kind of fact pattern. They say the applicant in this case had no symptoms prior to the industrial injury, and then they conclude and actually quote Escobedo, or make reference to Escobedo, and then they say, and thus, as per Escobedo, there is no apportionment. They actually get the legal theory backwards. And if I had $1 for every time I've seen this, I would be, well, I'd have $100 anyway. So well worth watching out for that one. When you're reading the apportionment section, take a look for that. I guarantee if you look long enough, you'll see that. Extends beyond the doctor's area of expertise. A doctor, if you're going to malpractice in one area of expertise, don't be malpracticing in other areas. We'll talk about that more later. And to determine whether there's substantial evidence, we're going to have to look at the entire record. We're going to have to look at the medical reports, the deposition transcripts, the testimony, etc. So, substantial medical evidence test. We look at the medical reporting requirements, and let's take a look at Kemp. Unless a medical report complies with Section 10606, which we just took a look at a little while ago, the WCAB rules neither the workers' compensation judge, the WCAB, nor the DCA can make a rational decision on whether such report constitutes the kind of evidence on which a reasoned decision can be based. So they need to follow the rules. We talked a little bit about reasonable medical probability. I want to come back to that for just a second. It's not true, and maybe this is a better way of looking at it. Reasonable medical probability doesn't mean that the doctor believes his or her opinion to a scientific certainty. The test isn't that tough. But it's also not a guess or conjecture. That's too little. It's bordering on speculative. It's somewhere in between. It's 50% plus a scintilla. Here's an interesting case. Death case. Fireman had lung cancer. And believe it or not, the WCAB said, hey, the defense wins this one. The reason was they said there was insufficient evidence brought by the applicant regarding toxicity of inhaled smoke. He said, we don't know what the toxicity was. We don't know how much was inhaled. We don't know the manner in which the inhalation resulted in the cancer. In short, there was no convincing evidence. And this went all the way up to the Supreme Court, and they said, wrong. They said the doctor had said that it was probable that smoke had caused the carcinogens, and that it may well be the same as cigarettes. Carcinogens come from an incomplete combustion. He explained how that works, and so that was sufficient. The injured worker inhaled the toxic smoke. It was reasonable to assume it causes cancer, and the applicant need not demonstrate toxicity amount inhaled. And let's take a look at this. Future scientific developments will tell us more about lung cancer. Ultimately, it might be possible to pinpoint with certainty the cause of each case of disease. But the legislature did not contemplate years of loss without injury pending such scientific certainty. Accordingly, we in the WCAB are bound to uphold a claim in which the proof of the industrial causation is reasonably probable, although it is not certain or convincing. We must do so even though the exact causal mechanism is unclear or even unknown. So I think we can all state that, or back a doctor who says to a reasonable medical probability, the inhalation of this smoke caused the carcinogens in the applicant's lungs. Report, I said that it's nice to use the medical words, reasonable medical probability, but they need not use them. It can go either way. If they don't use the magical words, it can still be found to be true to a reasonable medical probability. And if they do use the medical words, the magic words, the WCAB and WCJ is still in a position to say it's not true, that it's not true to a reasonable medical probability. What if the report provides, quote, a possibility of causation? That's insufficient. That's speculation. That's guess. Temporal coincidence. This happened at this time, this activity happened, and then this injury occurred. And there's a correlation, in short. Correlation is not sufficient. The doctor has to talk about cause and effect. Speculative, it's insufficient. It's insubstantial. We got, as we talked about earlier, surmise, speculation, and conjecture is not the ticket. Medical opinion must be based on the factual and factual and medical basis. Inference is okay. Conjecture is not. Another case, slip and fall. There was no treatment for 2 months. The QME said, okay, didn't treat for 2 months. There's no injury here. I mean, maybe go to a neuro for neurological disease, but there was no injury because they didn't bother treating for 2 months. The WCAB agreed. This too went to the Supreme Court, and they said, not so fast, bucko. Who decides whether the delay in taking the treatment, getting the treatment, was relevant? That's going to be up to the WCAB and the judge. The doctor's opinion that waiting around 2 weeks indicated that there was no injury, that's purely speculative. That's purely a guess. He doesn't know what really happened. Maybe the applicant was on a trip. Maybe they were sent away. Maybe they were at a funeral, what have you. It's purely a guess as to why they weren't receiving treatment for those 2 weeks. There's many possible reasons. Therefore, it's going to be up to the judge to make this decision. General rule, opinions based on scientific tests and studies equals substantial medical evidence. What you do want to look for are statistical correlations and probability relationships. That can be very, very helpful, particularly to the other side. A guess is complete disaster to the report. Note, if the doctor says guess or speculative, but the report is actually substantial medical evidence, it can come in. By the way, speculation speculation is a bad word, but if the WCAB says that's okay, it's sufficient, that it is not true speculation, that there's enough evidence to support the doctor's, there's substantial evidence to support the doctor's reasonable medical probability, then the doctor's report will come in. Think about apportionment when you think about speculation. In this case, the doctor admitted that it was speculative in a sense. And the question was, is this substantial evidence? And it was held, yes. Think about apportionment. All of it has to be speculation of some sort, in a sense. It's not a guess, and that's what speculative would be. But speculation in a sense, because there's no machine that you can put an applicant in, like an MRI, that ascertains that half of this disability is due to injury AOE, COE, and half of it is due to pre-existing factors. There's just not a CT or an MRI scan or an X-ray that'll do that job. So the doctor must make an estimate, a kind of speculation, although it's not really speculation, because if it were speculation, it wouldn't be admissible, but a sense of speculation. And that's exactly what they said here. Of necessity, every medical opinion must be, in a sense, speculative, and this does not destroy the probative value of such opinion. That having been said, if the doctor in your report says it's speculative, please get to the doctor and get them to correct that. The honest medical opinion of a specialist in a given field is proper evidence upon which the board may rely on making a award, and will constitute substantial evidence, even if the opinions are not based on a verifiable certainty. Of course, they're not based on a verifiable certainty. Virtually none of the medical opinions that we'll deal with in workers' compensation are. What if the opinion is wrong? It's not substantial evidence. How can a medical opinion be wrong? In many ways. Let's take a look. Fact pattern. Multiple body parts. Doctor says not disabled. And the doctor failed to find a ruptured disc, which was later diagnosed. It was held that you couldn't rely on this report because it was wrong, demonstrably erroneous. What about facts supporting the opinion being false and inaccurate? The doctor says in this report the cancer was not caused by asbestos. The reason being, no asbestos was found in the applicant. Makes sense. There's no asbestos found in the applicant. How could that have caused the cancer? Later on, it was found out that, it turns out that the applicant did have asbestos in there. In short, the initial report was false and inaccurate, to coin a term, and therefore insubstantial evidence. Another way that reports can be insufficient if the facts are no longer germane. In short, most medical reports have a certain shelf life. Oftentimes, they're very short. This is the reason the judges are very inclined to offer an OTOC because of quote-unquote stale reports. Applicants and defense folks alike who want to get an extension on the MST will often rely on, Your Honor, these reports are stale. They're 6 months, 12 months, 18 months old, and this often works. The report must be relevant to and provide an accurate depiction of the current medical condition, and if it can be argued with a straight face that that's not true of the older report, then you're probably going to get the OTOC. Here's a case, fun one. 42% F&A, new and further. In new and further, they were committed to a mental hospital. The WCAB, believe it or not, relied on the original medicals and found a defense win. Supreme Court, again, a lot of Supreme Court cases here, annulled, saying the WCAB relied on medicals but failed to consider significant subsequent events. Because of that, the evidence was unrelated and not probative. Let's not discriminate. Old does not necessarily mean insubstantial. And as a 55-year-old, I definitely want to believe that. Alleging the report is out of date must be specific and supported by the evidence. You can't just go down on the board and say, this is old, Your Honor, it's a year old. The judge is going to say, why is that a fact? Not that why is that a fact, but why does it matter that it's old? Reports predating the trial by years can still be sufficient if the facts if the essential facts that the board is going to rely on haven't changed. What about inadequate histories and exams? What if there's no history from the applicant at all? Is that substantial evidence? Probably not. What if the history material to the conclusions is inaccurate? Not substantial evidence. False histories. We've dealt with that for years and years, particularly with the days where we had a lot more fraud. Great opportunity to attack and win on AOE, COE. In this particular case, the applicant said I had a major argument just prior to the heart attack. Of course, it turns out that, quote unquote, just prior to the heart attack was months before the heart attack. Nonetheless, the AME, relying on the applicant's view of the facts, decided that the job stress, including the major argument, contributed to the heart disease. Once the truth came out, the report was found to be not substantial evidence because of the false and inaccurate history. Now, I know our friends down at the board are no stranger to exaggerations. We see that all the time. The real question is going to be, how extreme is the exaggeration and how material is it to the doctor's conclusion? Just because the applicant is exaggerating, I'll hazard to bet that the vast majority of the cases our WCJs see include at least some amount of exaggeration. I know in the hundreds of depositions I've taken, I can look at just a handful in which there probably wasn't any exaggeration, but that's not going to decide whether the applicant wins or loses the case. Inadequate history, problematic. There was a case, this is like suggested earlier, a teleconference. There was a telephone exam regarding an orthopedic injury. That was found not to be substantial evidence, and that makes a heck of a lot of sense. I mean, think about it. You're going to have to lay a hand on the applicant and help them move around to determine strength, et cetera, et cetera. Telephone examination for an orthopedic injury, I can't imagine ever being substantial evidence, even if it's a teleconference. Even if, I'm sorry, strike that. Even if you can see one another. But what about video conferencing exams where it's a psychiatric examination or a dermatological problem? I can imagine that being found to be an adequate history, but we haven't seen any case law on that, at least in the workers' compensation system, to my knowledge. Incorrect legal theories. Sometimes doctors don't limit their malpractice to medicine. I've already talked about that in terms of the Escobedo decision. They must know and understand PD, TD, MMI, apportionment, etc. We emphasized this already a couple minutes ago with the apportionment. I find this very interesting. I've seen a lot of doctors who have an incorrect understanding of workers' compensation. They fail to find the applicant PNS or MMI because they believe this will result in a cutoff of medical care. I've seen that in a number of depositions of doctors. Why haven't you cut off their test? Why haven't you cut off TD? Well, they still need medical treatment. It's a wonderful testimony to get. Be sure that you explain to a doctor who's keeping the person on TD for an extended period that this will not cut off their medical, and you may very well encourage the doctor to cut off the TD. Incorrect legal theories regarding apportionment, we just talked about that. We did so in terms of Escobedo. Let's get the facts and figures from Gatton. The doctor, for substantial evidence on apportionment, must demonstrate the understanding of apportionment, see Escobedo, detail the nature of that which is being apportioned, and define the basis for the doctor's opinion. I strongly recommend that you read the Escobedo decision because in that case, Dr. Ovadia provided a one-sentence explanation as to why he was apportioning 50-50. One sentence, and yet the WCAB found that to be substantial evidence. So that it's not a tough putt. The doctors just have to explain. Are you ready for this? We actually had a case in which the QME testified he would not apply Alvarez-Guzman, even where if it were legally appropriate. Not surprisingly, that was held to be not substantial evidence. Reason, it was an incorrect legal theory. Some people some of our friends at CAW might think it's a laudable or admirable incorrect legal theory. I don't tend to agree with that, but nevertheless, it was insufficient. So when you're taking a doctor's deposition, you might want to be quizzing him or her indirectly as to their knowledge regarding the rules of workers' compensation. You'd be amazed. These are doctors. They went to medical school to learn medicine. Very few of them are experts in workers' compensation, and we can undercut a doctor's opinion in this way. If the doctor fails to explain their opinion, they're not allowed to be conclusory. without an explanation, how can the WCAB possibly weigh the evidence? How can they assess whether it is supported by a reasonable analysis? Let me give you an example. This is a case that came down back around 2006. If you remember, there were some debates as to when we would use the 2005 permanent disability rating schedule and when we would use the 1997 schedule. And we on the defense wanted to use the 2005 schedule because that used AMA guides and resulted in significantly less permanent disability. By the same token, our friends at Call wanted to use the 1997 schedule for more, in hopes to get more PD. And the rule was this: the 2005 permanent disability rating schedule would apply to dates of injury on or after 1105, but also to injuries prior to 1105, quote, where there has been either no comprehensive medical legal report nor report by a primary treating physician indicating the existence of PD, the existence of PD. So applicant's counsel in this case, quick like a bunny, just before January 1 of 2005, went to the PTP and said, hey, what do you think about the existence of PD? And the doctor issued a one-sentence report. I believe PD is within reasonable medical probability emanating from this injury. Applicant's counsel said, see, here, I've got a report showing the existence of permanent disability prior to 1105. I get to use the 1997 schedule. What do you think the WCAB said about that? This one sentence, does that seem sufficient? The answer was no. They did not succeed in bringing this under the 1997 schedule. Why? Because it was not substantial evidence. And there was no explanation to support the conclusory statement. I believe PD is within reasonable medical probability. I believe that unicorns exist. I believe that there's a Loch Ness monster. There's got to be an explanation for this, and the doctor simply did not explain that. All right. Other unaccepted conclusory statements. I believe it's fair. I believe it's reasonable. And we talked about Escobedo. So I'm not going to go back to talk about that anymore. We've got more on apportionment. We've got more on trial prep and presumptions, which we will talk about at our next discussion. That next one should be our last one. I'm going to put you back with Tammy for a second.